Hi, everyone. Thank you so much for attending our webinar today. Before we get started, I just want to run through a couple of housekeeping technicalities. If everybody could do me a favor and let me know if you can hear me or if you're having any audio troubles, that would be great. I'll give you a few minutes to let us know. Okay, it looks like some folks can hear me. Okay, well, it seems like some folks can hear me and maybe others are having difficulty. I will work with you individually to troubleshoot any audio problems. If you have any audio problems at all, you can type it into the chat box and somebody will assist you. So now I'd like to hand it over to Maura McInerney, Legal Director at Education Law Center.
Thanks so much, Chelsea. So today's webinar will focus on the role of protection and advocacy agencies in addressing issues relating to children in the juvenile justice system. Even with the decline in juvenile crime and incarceration over the past 10 years, we all know that youth with disabilities, particularly those with intellectual and developmental disabilities, are being incarcerated at higher rates. One study reports that 65 to 70% of youth involved in the juvenile justice system have a disability, 3 times higher than the rate compared to those without disabilities. Protection and advocacy systems, which work at the state level to protect individuals with disabilities by advocating for and empowering them, can play a critical and integral part in assisting advocates to improve the quality of educational services provided to our youth in juvenile justice placements. Today, we're going to learn more about the role and the function of P&As, the scope of their investigative authority, and how litigators have and can use P&A reports and investigations as part of their litigation strategy and also through co-counseling. Our presenters will also address issues relating to associational standing and applicable rules and practices covering co-counseling and how litigators have been effective in partnering with P&As. And with that, I'd like to introduce Diane Smith-Howard, Senior Staff Attorney at NDRN. A litigator with over 20 years' experience in juvenile and educational law, Diane's work at NDRN focuses on conditions for youth in the juvenile justice system and child welfare systems. In addition, she works on issues relating to adults with disabilities in the criminal justice system and children and youth with disabilities that impact behavior in the public education system. Diane has provided training and technical assistance to many P&As and networks across the country. She has worked for NDRN's Maine and Michigan affiliates as well, providing direct services to clients. So with that, I'm going to turn it over to Diane Smith-Howard, and we're so grateful to have you on the webinar today.
Thank you, Maura. I'm really pleased to have this webinar. I think it's very useful information, and I'm also very pleased to be sharing the mic today with Eaton Heilemann from Southern Poverty Law Center, because the P&A network has had a really long and productive relationship with Southern Poverty on these types of issues, and they have a lot of experience working with us. So I think it's a really good match. I'm going to talk very briefly about the history of the P&A network, but I don't want to go on too long about that. It's important, I think, to set the context. Back in the 60s and 70s, when this nation institutionalized people with disabilities at a very high rate, there were several exposés, including one by Geraldo Rivera of the conditions at the Willowbrook facility in New York, that showed the tremendously horrific conditions that people with disabilities were being housed within in these facilities, and also the failure to provide them with educational services and other programming. So Congress began its effort with the P&As by creating a protection advocacy for people with developmental disabilities program to provide legal services to address those needs for people with developmental disabilities. And then over time, additional protection advocacy programs were added. I think the next one was protection advocacy for people with mental illness, the PAMI program, eventually the PAIR program, which addresses individual rights for folks who don't fall within the other two categories of DD or mental health, and then Happy, Pat, and any number of others. I think at this point we're up to 8 specific P&A programs. Each P&A program is set up similarly, although each individual program, as we'll talk about later, is its own unique nonprofit. So we're bound together within a network, but each P&A agency is its own nonprofit organization. So the P&A network, as you'll see on your screen, is a national network of federally mandated organizations which monitor, investigate, and provide legal advocacy services for individuals with disabilities. P&As actually represent folks from birth to death. We're one of the only pan-disability organizations, and we cover the entire lifespan. And as we talk later, we're going to focus specifically on monitoring and investigation, as well as legal advocacy, because legal advocacy is the particular role that many people know P&As have, but they don't know as much about what we do for monitoring and investigation. A P&A entity exists in every state and territory, and for a consortium of Native American tribes in the Four Corners region, with a total of 57 P&A organizations. For example, there is a P&A in Puerto Rico. Many people have asked about that. Collectively, the P&A organizations are the largest provider of legally based services to people with disabilities in the United States. So P&As are a powerful force in terms of providing information to lawmakers and others about systemic problems within the system, because we are in every state. I think, Maura, there was a poll that folks are going to be provided to get a sense of what they wanted to hear about today and make sure that we covered all of their topics of interest. So I'm going to pause here and do the poll.
Terrific. The poll should be coming up on your screen right now, asking if you have worked with a P&A on a case previously. So feel free to respond to that poll, and we'll gather that information. We'll just give it a minute. Okay, so I think we have some responses here. So it looks like it's 40% answered that yes, they have worked with P&A on a case previously, and 53% report that no, they have not worked with anyone from a P&A on a case previously. I think we had one other question as well for the poll. Is that right?
There were one or two focused on topics.
There we go.
Yeah.
Okay. So I think folks can see the question. If yes, on which topics did you work with a P&A? Okay, so the results are that the top is education, 50%, criminal juvenile justice, 44%, and 6% other. Great. Okay, and this is our last poll question. What topics would you most like to learn about today? Okay, we should have those responses. So it looks like 47% responded they want to learn how to collaborate with P&As on litigation or policy work. 29% said P&A access. 12% said P&A standing, 9% drafting co-counseling agreements, and 3% other. Thank you all very much for participating in the polling. Really, really helpful information to start this discussion.
Yes, thank you. I really appreciate that because we want to make sure that the conversation we have here today is truly helpful for folks. So here's some examples of various logos. Sometimes people don't realize that an agency that they're working with is a P&A. And then NDRN, the National Disability Rights Network, is a membership organization and the training and technical assistance provider for the P&As. I'll leave that for you to read on your own. But essentially, we are the entity that creates the trainings for most of the P&As. And before we get into Special Investigation and Monitoring Authority, which is the next slide, I wanted to circle back just briefly because sometimes folks will say, well, I referred a client to the P&A and they didn't take the case. And the reason that might be is either the case doesn't have merit, although typically one doesn't know that right from the initial referral, but more likely the P&A has set its priorities and the area of that particular case referral is not something that particular P&A does. Each P&A polls its own state and determines its own case priorities because systemic issues may vary from state to state. We want to make sure that the P&A is addressing the most significant systemic issues. That said, I will say that almost every P&A does some juvenile justice work. And the majority of the juvenile justice work that's being done by P&As currently is systemic reform of conditions and specifically a focus on the educational conditions of kids within the juvenile justice system. P&As do a variety of other juvenile justice related issues, but that seems to be the one that fits most appropriately with the work that we typically do and have the best knowledge and understanding of. And as I'm sure most of the people listening here know, many kids enter the juvenile justice system and they do not receive appropriate educational services. They re-enter into the community on the other end of the system without having gained sufficient credit or a high school diploma and have trouble just transitioning back to their local public high schools. So these are some very significant concerns. The way that P&A juvenile justice cases that are systemic in nature often work is that the P&A, through its monitoring of a juvenile justice facility or its regular monitoring of the whole system of juvenile justice facilities, comes up with data and a list of concerns. That information becomes a report, which is either public or private. That report then leads the conversation, some negotiation with the State Department of Youth Services, whatever the state juvenile justice agency is. Generally, there is some sort of settlement, but maybe not of all the issues. And if there are any remaining issues, the P&A then litigates those issues, resulting in a comprehensive settlement. And some states, of course, are within that process. So that's sort of how it often works. And the reason for that is because protection advocacy agencies have special powers that other law firms don't have by virtue of our enabling legislation, the legislation that Congress put into place to create the system back in the 70s and 80s. So P&A's special powers typically include access, standing, investigations, and monitoring. So Congress granted P&As with the authority for unaccompanied access to physical locations where services are provided to people with disabilities and to speak in private with and or interview persons with disabilities and service provider staff in order to monitor for rights and safety violations, educate people with disabilities about their rights, or investigate allegations of abuse and neglect. And that allows access to service providers and individual records without a release in certain circumstances. So many P&As, just as a regular matter of course, visit and do a monitoring of each juvenile justice facility in their state on a regular rotation. And those are typically announced. They must occur during work hours, and the staff tour the facility, P&A staff tour the facility, talk to facility staff, meet individually with youth in a private way to get information from the youth about their experiences, and then share information with the youth about their rights. So that's a pretty common thing. And then while they're there, of course, that's where the education of rights occurs. And P&As have access to certain records in that process. So that's all information that occurs prior to litigation and prior to discovery. Then, in addition, if there is probable cause to believe that there has been abuse or a report of abuse or neglect, and we'll get into the details of that in a minute, P&As have greater authority to go in and investigate. Juvenile justice facilities, whether they are group homes or hardware or staff secure facilities, are all considered places that P&As have access to. And that issue hasn't really been a big matter of contention. I think it's come up previously, as has the idea that public schools are not facilities to which the P&A access applies, and that's been pretty much resolved. One thing we do experience is almost every time we initiate access the first time with a new entity, we have to face some sort of pushback. Almost every entity denies access initially, and then if we either send an appropriate lawyer letter or file a case, we almost inevitably win those cases, but usually we do expect some pushback. So if you're working with a P&A that's asking for access for the first time with an entity, you should be aware there may be a time lag while that access issue gets worked out. So ways to work with P&As, I'm going to go into the details of monitoring, investigations, access, and standing in a minute. But just generally speaking, other nonprofits and private counsel frequently use P&As for case referral, as we discussed. The P&A can help locate plaintiffs, and the way that works is that P&As are in the facility, and they, while they're doing their regular monitoring or an investigation, and they determine that there is a person who might be in need of legal services, they can get consent from that person to hand on their information. They cannot do so without consent under those circumstances. P&As frequently co-counsel with private attorneys and other nonprofits. For the very big cases, particularly criminal justice and juvenile justice systemic reform, there's often three entities: the P&A, a nonprofit organization like Southern Poverty, and then a private law firm, which in each player in that scenario brings something important to the table. And so the combination of the three can be really a productive way to litigate big cases. In addition, P&As can use their associational standing and be a plaintiff if there are no named plaintiffs for whatever reason under certain circumstances. In addition, P&As, even if they cannot share the details of what they've seen during monitoring and investigation, they have a lot of information that can speed up your litigation preparation process without, just because they know the system, they know the staff, they know which staff to talk to, they know which facilities exist and where they're located, they know which is staff secure and which is hardware secure. That sort of information is all publicly available, but a 15-minute conversation with the P&A can save you a lot of time as opposed to trying to get that information from the state agency or off its website. So it's just a shortcut that is not sharing information that isn't public, but can boil that down for you pretty quickly. P&As also do an enormous amount of public policy work on juvenile justice issues at the state, federal, and local level. We are often members of coalitions, civil rights coalitions, education coalitions, and disability rights coalitions. If you're working on a piece of legislation or you're thinking about a policy initiative, it might make sense to bring the P&A in. In addition, we also do community and grassroots work in some states, and it can be a way to connect up with the families of children with disabilities, along with perhaps the Parent Training Information Center in your state. And Eaton is going to talk about access agreements, so I won't go into too much detail there, but there are some circumstances within which a P&A may share its access with another organization. So those are some of the ways to work with P&As. And I think, Maura, we didn't talk about questions, but that's a lot of material. So maybe I'll take a pause here for a moment and see if anyone has any particular questions about ways to work with the P&As before I move on to sort of the legal aspects.
Yeah, if anyone has a question, if they can feel free to put it into the questions box, and then I will take the questions off of there and read them out and have our panelists respond. At this juncture, we do not have any questions that I'm seeing, but please feel free to populate that box, and as we move along at the end, we'll certainly have Diane respond to those questions. Thank you.
Then I'll move forward. Some of the common issues we see with the use of P&A access, just so you know what they are, so you know what not to worry about. The initial refusal that I talked about, sometimes an entity will say that HIPAA or FERPA prevents them from releasing the information in the records. Both of those arguments have largely been defeated. Sometimes they'll say that P&A staff are unqualified to be around young people in a state of crisis. Again, that is not an appropriate argument, or that the P&A's presence in the facility would upset safety or the productive treatment that's going on there. If that were the case, then we would never have access. So that's not an argument that held water very long. One thing that is significant, though, is that during monitoring and during investigation, any information that the P&A obtains is bound by the same confidentiality rules that the institution itself is bound by. So once the P&A receives information, it cannot share that information outside in any manner that the facility itself could not. So we'll talk about that more later, but that's pretty significant. And then another thing that's important to know is that P&As are able to request contact information for parents and guardians. And so that is a place that sometimes we see some game playing, that the facilities say, well, you can come in and you can talk to these people who are sometimes nonverbal, for example, but you can't get the name of their parent or guardian. And that argument has been defeated as well. Re-release, as I mentioned, the P&A has to follow the confidentiality requirements of the facility. So if a P&A obtains plaintiffs through monitoring, it can pass that information to outside parties with consent of either the client or the guardian. The P&A can get around re-release issues appropriately by providing a public report, and that's what sometimes happens. But whether or not a public report can be released or not is something that needs to be negotiated with the facility. And then, of course, co-counseling. But I think it's important to mention that if a P&A co-counsels with an organization or a private law firm, that law firm is also bound by those same confidentiality requirements. So it can be useful in terms of figuring out how to structure a discovery request, but in order to get that information into a lawsuit, it needs to go through the discovery process as well. You cannot take information from a monitoring and put it directly into pleadings. There needs to be a proper process in the middle there. And I think that's something that folks sometimes get a little bit confused about. So just to go over briefly the authorities for access, we talked about monitoring, investigation, and access. The statutory authority for P&A monitoring states that the P&A shall have access at reasonable times to any individual with a developmental disability in a location in which services, supports, and other assistance are provided. That's basically the same under both the PAD and the PAMI Act. And that's for monitoring. And then for investigations, the P&A shall have the authority to investigate incidents of abuse and neglect of individuals if the incidents are reported to the system or if there is probable cause to believe the incidents have occurred. So the higher level of access under investigations requires either an incident of abuse has been reported or probable cause. But one of the good things is, or two good things. One is the probable cause standard is not the same as it is under the Fourth Amendment. It's a little bit more flexible. And the P&A is given the authority to determine whether probable cause exists. That is not determined by the facility. So when P&As investigate, they may do one of four different kinds of investigations. They may do a primary investigation, which is to conduct direct investigation of an incident or condition. They may do a secondary investigation, which is an investigation of the investigation that the state did. Sometimes the state will do an investigation and come up with conclusions or a next step for the facility that does not match the problem. And so the P&A will investigate, look at the methods that were used, and issue a report making a different suggestion about how the problem might be resolved. For example, oftentimes the state might determine that staff training is needed when actually the problem is really budgetary constraints caused by the legislature or policies or just a general lack of oversight. So the P&A might recommend those more strident changes as opposed to additional training for the staff. The third type of investigation would be incident condition specific, looking at a particular incident, usually of either abuse, neglect, or a death. P&As frequently do death investigations in facilities. And the fourth kind of investigation is the systemic review of a suspected pattern or practice. And so these days, that tends to be more of what P&As do in addition to the typical restraint and seclusion investigation. So probable cause is a reasonable ground for belief that an individual with a developmental disability or a mental illness has been or may be subject to abuse or neglect, or is at significant risk of being subject to abuse and neglect. That's the PAMI standard. So PAMI has the additional risk piece, whereas PAD has a reasonable ground for belief that the person has been or may be subject to abuse or neglect. And the statute defines abuse and neglect as well. Now, access to facilities for investigations. A P&A shall have reasonable unaccompanied access for an investigation to services, supports, and other assistance, as we talked about. And in addition, we have access to the residents themselves under both monitoring and investigation. So when we're in the facility, we can either ask to meet with specific residents, or if we are there, we can ask to have a moment to speak with individuals that we run into while we're in the facility. And it can be either way. Sometimes, I think many P&As kind of when they're doing a monitoring do both. They ask for a review of a particular sample of files, they talk to those people, and then they also speak to folks who are sitting in the common room who might be available to chat. Reasonable unaccompanied access means that exactly what it says, that you can wander around the facility by yourself, and that's something, so long as you follow the rules of the facility, you do not provide a security risk. For example, if you need to give up your cell phone, you do so, and that you are appropriate. But generally speaking, if you follow those rules, the P&A staff is able to move around the building by themselves. Access to records. There is no authority to access general facility records or the records of an individual without consent under monitoring. However, when P&As are using their investigatory access, they have significant records access that is triggered once an abuse and neglect investigation commences. That's an area where there's often some concern and pushback by the facility. If it's an urgent situation, those records need to be provided within 24 hours. If it's not an urgent situation, they have 3 days. Access to records occurs when, under the investigation authority, either a client or their guardian consents, or an individual who has a guardian, P&A has contacted the guardian has offered assistance, and the guardian fails or refuses to act. The P&A may act in their absence. Or if there's an individual with a disability who cannot authorize access and does not have a guardian. In a juvenile case, frequently what happens is the child is also under state custody for abuse and neglect when they were children. So they have a state caseworker of some sort, and frequently we find that state caseworkers are reticent to get involved in P&A investigations. So we might need to use the investigatory access to get those students' files. I'll talk really briefly about P&A standing, and then I will hand it over to Eaton Heilemann. The standard for P&A, when a P&A can sue on its own behalf, is when the P&A has met all three requirements of the Hunt versus Washington State Apple Advertising Commission case, and that's at 432 U.S. 333. It's a 1977 U.S. Supreme Court. Again, Hunt versus Washington State Apple Advertising Commission, 432 U.S. 333, 1977. The P&A Act requirements indicate that the P&A must function as a membership organization similar to the plaintiff in a hunt, and that sufficient evidence must exist that specific individuals were harmed, the lawsuit is germane to the purpose of the P&As, and that the relief sought does not require an individually named plaintiff. And so there have been 2 recent cases that have upheld the rights of P&As to use their associational standing and to sue on behalf of individuals in a class who would otherwise not be able to access P&A, would not be able to access the legal system. This was put into place because oftentimes P&As represent individuals with developmental disabilities who cannot participate in their own lawsuit, nor can they, they don't have guardians who will speak for them, and they may be nonverbal. So this is a protection in place for folks who might be in danger of abuse and neglect in those circumstances. And the last thing I'll mention is that, especially in the juvenile justice context, P&As often work alongside public defenders, and P&As do not do criminal work themselves, but they can be very helpful at educating the public defender about the child's disability, the implications of that disability, so that it can be used in terms of developing, either diverting the child from the system or developing appropriate probation plans, and also to help determine what services are available for that use upon release, so that a reentry plan can be developed with that information. So I think, if it's all right with you, I will pause there, and then if people have any other questions, I will be on the line.
Okay. Thank you, Diane. We really, really appreciate that overview. That was exceptionally helpful, and I think we'll have some questions at the end about maybe some of the P&A access cases that I know a bunch of us have looked at. But I think I'd like to turn it over right now to Eaton Heilemann, Managing Attorney at the Southern Poverty Law Center. Eaton leads the Louisiana office of SPLC in New Orleans and works to ensure children's access to public education and to reform ineffective school discipline practices that push children out of school and into juvenile and adult prisons. She has authored several publications on the excessive use of harsh discipline and the exclusion of children with disabilities in public schools. So I'm going to turn it over to Eaton, who's going to talk about partnering with P&As to improve educational outcomes for youth with disabilities in the juvenile justice system. Eaton?
Yeah, thanks so much, Maura. I really appreciate it. And as Diane mentioned, it's really a privilege to be able to speak with people today and to also partner with the Education Law Center and Juvenile Law Center and NDRN on this webinar, because it's a really important topic, and I appreciate the chance to join this. I want to quickly just talk about, just to kind of start us off, about Southern Poverty Law Center, what our background is as an organization and what particular areas we work on, and how that has in turn resulted in us overlapping with the P&As and where our work kind of intersects, and then kind of go into some of the actual practice pieces of how our partnerships and collaboration with P&As have been on various cases, and then and talk about some of the logistics and setbacks, and then wrap it up with questions as well. So just to kind of give you a brief, quick introduction, I know a lot of folks are coming from a variety of different organizations who are on this webinar. Southern Poverty Law Center is not a disability rights organization specifically. We are a large civil rights organization. We have offices across 5 states in the deep Gulf South, basically. And our kind of primary 5 practice areas are children's rights, which includes education and children's mental health, criminal justice reform, which includes juvenile justice and adult decarceration efforts, economic justice, LGBT rights, and immigrant justice. And many times our work in these various 5 areas directly implicates the rights of adults and children with disabilities. And so this has given us a way to partner with the P&As on a variety of cases that have been of interest to both our organizations. When these overlaps occur, we've had an opportunity to partner with a P&A to pursue an investigation and potential litigation. We've been very fortunate having to get the chance to work with these organizations throughout the South. So just to start us off, I wanted to kind of talk a little bit about some of the partnerships we've had with P&As in our states that we have offices in. We've probably partnered with P&As on about a dozen or so cases, if not more, over the past 10 to 15 years. And so as Diane mentioned, we've really been fortunate to kind of have created a long and solid alliance with our respective organizations, working together on a number of issues. So while this webinar focuses obviously primarily on educational outcomes for youth with disabilities in the juvenile justice system, we've collaborated with P&As on a number of issues affecting people with disabilities. So I wanted to kind of give you a sample of some of these issues to think through in terms of work on these areas. So the first one is a case we have in Alabama, actually, which is ongoing, called Braggs v. Dunn. In this case, SPLC partnered with the Alabama Disabilities Advocacy Program, also known as ADAP, which is the P&A in Alabama. And we worked together. We entered into an agreement to investigate the conditions in Alabama's prisons, and we released jointly a report called Cruel Confinement, Abuse, Discrimination, and Death within Alabama's prisons. Very morbid title. And we actually filed this or released this report jointly right before filing suit. We ended up co-counseling the case with ADAP against the Alabama Department of Corrections, and ended up with a landmark consent decree recently entered into about the prison conditions in Alabama. We have another second stage of a trial coming up relatively soon, but we are continuing to work with ADAP on that case very closely. The second case I wanted to just quickly highlight as a different example. It's a case we worked on in Mississippi about Mississippi youth in custody, and this is kind of more tied to the issues that we are looking at for this particular matter, which is, the educational outcomes for kids with disabilities in the juvenile justice center system. And so this case was JHV Hinds County, and we partnered with Disability Rights Mississippi to investigate and litigate inhumane conditions of confinement and inadequate access to education for youth at a juvenile justice center in Mississippi called Henley Young. We did the investigation together, litigated the case together, and ultimately resulted in a consent decree, and worked on monitoring together as well. In Mississippi, we've actually partnered with Disability Rights Mississippi a number of times on a variety of cases. We've actually even had to litigate access authority and the ability of Southern Poverty to come in with Disability Rights Mississippi to investigate facilities there as well. So we'll talk about that a little bit when we get to that section, but we've been fortunate enough to partner with Disability Rights Mississippi in a number of different contexts. And the last one I wanted to quickly mention is one that I'm personally working on now, which has not resulted in a case yet, but it has been a very strong partnership thus far. Right here in Louisiana, which is where I'm located, we have partnered with the Advocacy Center, which is the P&A in Louisiana, and we've entered into an access agreement to jointly investigate the failure of the Louisiana Department of Health to provide home and community-based mental health services to Louisiana children with emotional and behavioral disabilities. And the goal of our partnership at this point is to we've gone into facilities, to psychiatric residential treatment facilities to interview youth with the Advocacy Center, and our goal is to jointly build up, hopefully, litigation, systemic litigation together, and co-counsel the litigation moving forward. So that's a sampling of some of our cases that we've worked on with P&As over the time. So I wanted to quickly talk about kind of how we approach case investigations with the P&As and how we kind of enter into this whole process. So first, as Diane mentioned, the specific laws that allow the P&A to have to contract with another organization very clearly says that P&A has authority to contract with nonprofit organizations that are in the state within which they practice, 2, that are independent of any agency that provides treatment or services to individuals with disabilities, and 3, have the capacity to protect and advocate for the rights of individuals with disabilities. And so if your organization meets these qualifications, then you have the ability to co-counsel and or enter into an access authority agreement with a P&A in order to conduct investigations into various facilities. So I wanted to quickly talk about, and Diane mentioned this as well, but quickly talk about the difference between an access authority agreement versus a co-counsel agreement. You know, typically these are not the same thing. A co-counsel agreement obviously is the preferred approach because then you can litigate the case together and you investigate the case jointly and build it up. However, there are instances in which, as Diane mentioned, the P&A may serve a different role or want to serve a different role. So for example, the P&A may actually be an organizational plaintiff or an associational plaintiff, or may not have the capacity to be involved for whatever purpose or reason. And in those instances, you'll have the ability to talk to the P&A and to negotiate possibly an access authority agreement. And so what an access authority agreement is basically it's a signed contract that allows the cooperating organization to almost become and functionally operate as the P&A for purposes of going on site and conducting investigations. But I will say that with great power comes great responsibility. So when you are in the context of providing these, the monitoring visits and the abuse and neglect investigations, you have the same responsibilities that the P&A does in terms of reporting and confidentiality and all of the other rights and privileges. So a couple of things I wanted to quickly mention is that first is that the cooperating organization becomes authorized to investigate incidents of abuse and neglect for individuals with disabilities. And Diane talked about this in terms of the statute. I wanted to quickly talk about how broad of an issue this is. So abuse and neglect of individuals is actually not just kind of physical and abuse and neglect, which most people think of. It also can take many different forms. It can include things like unsafe and sanitary living conditions, not getting enough food, forced or excessive medications, improper use of seclusion, punishing children for behavior that is part of their disability, inadequate educational programming. So, for example, what we're talking about here in this particular webinar, that's a form of abuse and neglect, inadequate mental health or medical treatment, or a lack of proper discharge planning. So all of these things can also be considered abuse and neglect and can be subject to monitoring and investigation by the P&A. As Diane mentioned, it's important to note that P&As are entitled to reasonable unaccompanied access to facilities. So this is really important to note, something that we've come into contact with here when we've partnered with the P&As to do facility visits. In Louisiana, what we typically have done is we've asked for a tour of the facility with the administration just to get us started. And then we usually ask for unaccompanied time to speak with the individuals directly in the facility. And we've had some folks try to linger and be a part of that, and we've had to make, draw very clear lines and explain, okay, no, we need to be able to speak with them without them being supervised. And so that's an important part of the authorities and rights as well. Another quick important note I wanted to mention is that the access authority applies to both public and private facilities. We've had private facilities argue that access authority doesn't apply to them because they are private and therefore they don't have to follow the law in this regard, and that is inaccurate. It's both public and private facilities, so that is an important thing to note as well. So in terms of right to access to records, so the P&A right to access records generally hinges on probable cause to suspect abuse and neglect. So when you make a written request for records, you need to allege that you are investigating neglect under the PAMI's definition of neglect. And under the statute, records must be provided promptly. The Development of Disability Act defines this as 3 business days. While PAMI doesn't specify a time limit, we typically try to argue same for the 3 business day limit. The cooperating organization and or P&A also may be subject to a reasonable charge to offset copies, so that can be expected as well. And one other thing that I wanted to just quickly mention that I think is helpful, at least for us when we were prepping to start going into facilities and doing visits, is to read TASC, the Training and Advocacy Support Center, which is a division of NDRN, puts out a P&A system access manual, which is an incredibly helpful guide to access monitoring and records. This kind of became our Bible in terms of, internally when we were going to start doing these P&A visits, to make sure that we understood really fully the full scope and range of both privileges and responsibilities that came with access authority. And so I highly recommend, if you partner with the P&A as co-counsel or through an access authority agreement, that you review this manual very carefully. It's available, I believe, on NDRN's website. So some of the things that we deal with in our access authority agreements, also are in our co-counsel agreements with the P&A when we've done this before, is one, we try to spell out the process for establishing a joint schedule for monitoring facilities and identifying the attorneys or advocates responsible. The schedule itself doesn't need to be part of the agreement, the co-counsel agreement or the access authority agreement, but I think spelling out a process for how you will do it and how you will jointly monitor, whether or not it will be, that the cooperating organization will be the one going and will report back to the P&A, that it will be jointly, and that both, parties will submit a schedule monthly of who will attend what visits, what date, but identifying what that process will look like is pretty important, so that there's not miscommunication about who will be attending visits and what kind of staffing capacity is necessary. The second thing that we've included in our agreements that I think is really helpful is spelling out the reporting structure. So again, you have a responsibility to ensure that the P&A knows and has awareness of what happened when you went on your monitoring visits. And so typically in our agreements, we've really spelled out that the advocates assigned to conduct the visits will produce a written report of each visit within 1 week of the visit, so that we have in there concretely when the P&A can expect to receive the report from the visit. And the third thing I wanted to highlight here was, the agreement kind of could either authorize the cooperating organization to pursue legal administrative remedies with notice to the P&A, or it may require a separate co-counsel agreement. And we've done this both ways. We have some access authority agreements, for example, the one that we used in Alabama, which gave Southern Poverty permission to, with consultation to ADAP, to enforce the access authority agreement in court as necessary in terms of, going against a facility for not providing access. In other agreements, like our one in Louisiana, we very clearly lay out that this is an entry agreement and that we will circle back with a follow-up co-counsel agreement that will lay out our co-counsel relationship. So I think making sure that this is clear in the initial investigation agreement is really important. So some of the common problems that we've had when we've done some of our access authority monitoring visits, and these were some of the issues that Diane raised as well. One is the facility denies the cooperating organization the right of access to the facility. Some of the arguments that we've gotten, for example, are no, we are a private facility. No, we don't know what this law is. Who are you? No, we only allow the P&A in. We don't allow you as this cooperating organization in. So those are some of the kind of common arguments we've gotten. There's also the argument of a facility trying to forbid access to juveniles without parental consent. The Pay Me Act directly addresses that and says the right of access shall apply despite the existence of any state or local laws which restrict access to minors. But that is something that we have heard as well. And then finally, the kind of third denial problem is when the facility allows you access to monitor, but then denies you the right to actually access and review records for individuals or the facility. When we've encountered access problems in our various offices, we typically work with the P&A to try and contact first an attorney for the facility. In our experience, usually the attorneys have at the very least, the ability to pull up the law, to get a better understanding of what the rights and responsibilities are, and then you can negotiate, a time and place for access. So usually that's kind of our first line of action. If we, aren't able to work through an attorney, or if the facility does not have an attorney, we typically send a letter outlining the law and kind of rebutting the facility's denials of our access. So, for example, laying out very specifically what the P&A's statutory access rights are, that the P&A has the ability to contract with our organization, and then at the very end kind of have a clear ask to schedule another visit. And then if that doesn't work, the third option is really to litigate access authority. And we have done this before in our Mississippi office. We have not done it in Louisiana, thankfully, yet. But in litigating access authority, typically the P&A sues the facility that's denying the access. Because it's under the P&A Acts, it goes under federal court jurisdiction. Injunctive relief is available, and attorney's fees and costs are recoverable. The case law, as Diane mentioned here, is abundant and pretty good in terms of affirming P&A authority to conduct monitoring, and also P&As having the ability and right to contract that authority to another organization. And again, like I mentioned, we had to file an access authority case in Mississippi when we were denied, and prevailed.
I would just add that it is remarkable the breadth and scope of access excuses, but typically it seems as though once they receive a letter or you threaten to sue, in most cases they seem to back down. Absolutely.
Absolutely. And it's, I think, in part because the case law is so very clear. I mean, really, in pretty much every circuit. If anybody is interested offline, I can send a list of some of the cases that have reaffirmed this. But
that would be great if we could share that with the group.
Absolutely.
Thanks.
It's very strong. So yeah, so that's basically, the gist of some of our work. I do want to, again, highlight that, if preferable, and I think for most of the P&As, it would be preferable to enter into co-counsel agreements and to approach the entire process as one of partnership from the beginning, both in building the investigation and kind of the monitoring phase, and then exploring the legal case theories and moving into a co-counseling phase. As I mentioned, we have entered into just access authority agreements without co-counseling in the past for a variety of reasons. And while, this has been helpful, and, we're incredibly appreciative of the P&A's help with this, I think that the better approach in most instances is to approach these investigations with the intention to co-counsel the case. And so I didn't know if, Diane, if you wanted to add anything on that piece as well.
Yes, and before I forget too, I should mention that Senior Staff Attorney David Hutt at NDRN is our contact person and technical assistance provider specifically on P&A access monitoring and investigations. He's the person that the P&As call when they encounter an access issue, and he's given me permission to give his email, and he would have at his disposal all of those cases and all of that information. He's the one who writes the access manual. He is david.hutt, H-U-T-T, at ndrn.org. So you should feel free to contact him if you run into a snag, because he's really the best person on that. Yeah, I think, each P&A and each organization needs to sit down together and figure out what relationship is going to work best for them. In some cases, the P&A doesn't have the resources. Maybe, some P&As only have one staff attorney. So in that case, maybe the P&A would write a report, and then the organization would pick that report up, and the P&A would not be involved at all after that, depending on what the P&A's capacity is. Co-counsel agreements we think are best, because then you bring the power of both organizations. Like the Southern Poverty, they have such a long history of civil rights litigation, and then the P&A has the disability specific piece. So it's always, I think, good if you can marshal all the forces you have. But there are times also when the access agreement is the best choice. So I think it's really important for each group to sit down together and figure out what's going to work. I don't know if we have a specific answer to any particular thing, because it depends on the case. And also there may be other issues that are not disability related that, like, you know, Title VI issues that want to be rolled in. So it's not, but I think most P&As are finding these days that co-counsel agreements make good sense, and particularly if it's a 1988 case where fees are available, that just spreads the love for everyone a little farther.
Absolutely.
Thanks to both of you. I was going to jump in with a few questions at this juncture, but I did have a question about what circumstances would it not be preferable to do a co-counseling arrangement, or is that maybe the particularities of the P&A? Are there any reasons why it would be better?
But yeah, I think one type circumstance might be where the P&A just doesn't have the capacity to do the work, and so they contract with another agency. Like, I know in the past, Southern Poverty has, I don't think it happens so much anymore, but has acted basically as the P&A on those particular issues. So that would be that kind of circumstance, or when, you know, as Eaton said, there's great power and responsibility with an access agreement. So, you know, it's pretty specific organizations that have that capacity and also have that interest. Yeah.
Okay. So one of the questions that we've received is whether public schools and charter schools are covered under P&A access.
Oh, they are.
Okay. Another question, actually, this is with regard to access authority litigation, because it does seem to be routinely favorable to P&As and recognizing their authority. Are those cases fast-tracked, or do you typically file a preliminary injunction? One of the concerns might be that, is this such a, just, you know, kind of throwing up a roadblock, denying you access, so that they can maybe clean up the act, so to speak? Any thoughts on that?
I can tell you what. Go ahead.
Yeah.
I was just going to say, we filed a preliminary injunction and got a hearing quickly. I do think that obviously the faster you can get before a judge, the better on these issues.
Great.
They often settle. Of course, when they settle, they do get a few additional extra days there to mop and clean up the nutrition situation. And some of the cases we see are really basic, like children not getting enough calories. So it's, you know, any stalling does behoove them, but they are pretty quick, I think, for the most part.
Mm-hmm. And how many P&A investigations, and maybe you don't know this off the top of your head, but just a guess, result in litigation? Is that typical, or?
In access authority litigation, or in litigation on what the underlying is?
Result in litigation of underlying claims.
I would say less often. I think more often what happens is that there is the investigation results in a report, which then eventually becomes a settlement. It takes a while, but I think more often than not, these cases settle, although I'd probably refer to David Hutt on the specifics of that.
Mm-hmm. And is it typical that advocacy organizations are calling P&As, bringing things to their attention, or does it work both ways?
In our experience,
more often. Oh, go ahead, Anita. Go ahead.
I was just going to say, I think in our experience, we've had it go both ways in our states, where we've both kind of jointly expressed interest in an issue and then have like kind of partnered together as something has developed or as a case might have come up. So, for example, if an individual clients were being, calling the P&A about a particular issue, and we had already met with the P&A to talk about how we were interested in the same issue, the P&A might call us to loop us into that, and then we can go from there. But on occasion for us, it's been vice versa, where we've approached the P&A to say, like, we have concerns, we've heard X, Y, and Z, we would love to work with you to investigate this.
That's great. That's really helpful. Diane, did you want to add anything?
No, I think that's right. I think it used to be more that other organizations approached us, but I think more that now that P&As are doing more of this litigation on their own and more of that planning, I think it is more often that we reach out to others.
Well, thank you both very much. On behalf of the Legal Center for Youth Justice and Education, I just want to thank both of you for presenting today. The Legal Center is a national collaboration of the Education Law Center, the Southern Poverty Law Center, the Juvenile Law Center, and the ABA Center on Children and the Law. And we urge you to visit our website, which is jjeducationblueprint.org. Again, that's jjeducationblueprint.org. You'll see that we have a blueprint there that highlights resources, policies, practices, model legislation to try to improve educational outcomes for youth in the juvenile justice system. And in addition, we urge you to contact us directly with topics that you would like to hear covered on our webinar series. We'd really like to find out more about what's going on in your jurisdiction so that we can continue to update our blueprint for change. And we look forward to continuing these discussions in the future. Thank you so much to our experts, to Eaton Heilemann of Southern Poverty Law Center, and to Diane Smith-Howard of NDRN. Thank you both for your expertise and sharing your knowledge today. Thanks, everyone.
Thank you for having us.
Thank you. Bye-bye.